The maximum penalty for dangerous driving occasioning death is 10 years imprisonment. It increases to 14 years imprisonment where there is one or more circumstance of aggravation. It's what's known as a strictly indictable offence, which means it must be heard in a higher court, such as the district court. And the offence is subject to what's known as a guideline judgment, which says that a custodial sentence, that is a prison sentence, will normally be appropriate unless there was a low level of moral culpability. For example, if the offence came about due to momentary inattention or a misjudgment. Some of the factors to be taken into account when imposing a sentence are the number of people potentially put at risk by the driving, any degree of speed, any degree of intoxication, if there was any erratic or aggressive driving or competitive driving or showing off, the length of the journey during which others were exposed to risk, any ignoring of warnings, any degree of sleep deprivation, any failure to stop when required to do so. The Judicial Commission's sentencing statistics for dangerous driving under the influence of alcohol or drugs state that the most common penalty was imprisonment. That was 88% of people. The average full term was 36 months imprisonment, and the average non-parole period was 18 months imprisonment. And the non-parole period is the time that you must spend in prison before being eligible to apply for release out of prison. Intensive correction orders and suspended sentences accounted for 4% of people each. For dangerous driving at a dangerous speed, there was only one case recorded in the statistics, and that person received an 18-month non-parole period and a 24-month full term of imprisonment. For dangerous driving in a dangerous manner, the most common penalty was again imprisonment, this time 56%. Suspended sentences accounted for 24%, and intensive correction orders accounted for 10%. The average full term of imprisonment was 36 months, and the average non-parole period was 18 months. Higher maximum penalties apply where the prosecution can prove one or more circumstance of aggravation, and these make the offence of dangerous driving occasioning death more serious. Circumstances of aggravation are where a person's blood alcohol concentration is at least 0.15, that is, in the high range of drink driving, or where a person is driving at a speed of at least 45 kilometres over the speed limit, or where a person was driving to escape a police pursuit, or where a person was driving when they were substantially impaired by a drug or combination of drugs. For aggravated dangerous driving causing death, all of the people went to prison. The average full term was 5 years, and the average non-parole period was 30 months. If you are convicted of dangerous driving occasioning death, then you must be disqualified from driving. The relevant disqualification period will depend on whether it's your first or your second or subsequent major traffic offence within the previous 5 years. A major traffic offence is one that you received a court attendance notice for and had to go to court for. For example, drink driving, driving while suspended or disqualified, dangerous driving, and so on. If it's your first major traffic offence, then the automatic period of disqualification is 3 years for the first offence. The court may, however, reduce that down to a minimum of 12 months if there are good reasons to do so. For example, if you have a very strong need for a licence and you have a very good driving record. For a second or subsequent offence, the automatic period of disqualification is 5 years. However, the court may reduce this down to a minimum of 2 years, again, if there are good reasons to do so. If it's your third or more major traffic offence within 5 years, then the RMS will declare you what's called a habitual traffic offender, and they will whack on an extra 5 years disqualification to your court-imposed disqualification. If the case against you is very strong and you wish to plead guilty, a good lawyer may nevertheless be able to push for an aggravated charge to be downgraded to a non-aggravated charge, or they may even be able to push for a less serious charge category. For example, negligent driving occasioning death, which has far lower penalties. They may well be able to ask for the police facts to be amended so that the circumstances of the offence appear far less serious. They will be able to help you to prepare for your sentencing hearing by telling you how to prepare character references, a letter of apology, to undertake a traffic offender program, and they'll be able to fight for the lowest possible penalty in court, fight to keep you out of prison. They may be able to fight to reduce your disqualification period also. If it's your third or more major traffic offence within the previous 5 years, they can ask the judge also to quash the habitual offender declaration.